Hello, guys, and welcome back to our YouTube channel Study Time Anytime. Today, we'll continue the case law series for our Constitution of Canada, and we have already completed 5 case laws in our previous video, and now we'll start from the sixth one. The sixth important case law that changed and defined the era of constitution and the freedom of rights in Canada is the woman's right to liberty and security. So the brief facts of this case are as under. Doctors Morgentler, Smoking and Scott ran a clinic in Toronto that performed abortions for women who did not have a certificate from an accredited or approved hospital as required by the criminal code. The doctors were charged with the intent to provide abortions in violation of the criminal code. The majority of the Supreme Court decided to strike down the abortion provisions in the criminal code because they forced women to carry a fetus to term unless they met certain criteria like getting a certificate. Legislative scheme prevented many women from obtaining a legal abortion even if carrying the fetus would cause them psychological or physical harm. This was considered to be a violation of the right to security of the person because it interfered deeply with the woman's bodily integrity. Justice Bertha Wilson also held that this law interfered with the woman's right to liberty since it did not allow the women to make crucial decisions about their own life or health free from state interference. So in this case, it was observed by the court that women are actually forced to give birth to the children, and getting a certificate for a pregnant lady is much more difficult, and the criminal code is applying force on them to carry on with the pregnancy and keeping aside all the aspects of their health, of their liberty, their freedom, their psychological position, and keeping them aside brings the woman liberty at halt. So the majority of the court also found that the provisions were not demonstrably justified in a free and democratic society because they did not advance the state's purpose of protecting the life and health of mothers. Since the parliament did not pass any law in response to this decision, abortion is no longer a criminal offense in Canada. So it was held in R versus Morgentler in 1988, 1 SCR 30. Next case is giving real meaning to the equality rights for everyone in Canada. Mark Andrews met all the requirements to become a lawyer in British Columbia, but he did not have Canadian citizenship because he did not meet the citizenship requirement. He was not accepted so. Andrews challenged the provincial law which prevented him from being a lawyer, arguing that it was discriminatory since it treated non-citizens and Canadian citizens differently. Majority of the Supreme Court decided that the provincial law infringed equality rights because it did not let otherwise qualified people practice law solely because of their citizenship. The very important purpose of this judgment is to bring equality among all the persons, all the humans, keeping aside the status of their citizenship. There cannot be any discrimination for any person, whether he is a citizen of the country or not, for doing or a business or conducting a business or professing any profession. So this case was the court's first decision on equality rights. It has influenced the development of equality law well beyond the specific facts of Mr. Andrews' case, because Justice emphasized that Section 15 of the Charter protects and promotes substantive equality of opportunity for all. This deep understanding of equality has had a profound impact on the Canadian law and on people's understanding of equality all over the world. So, Justice had clearly mentioned the provision of Section 15 of the Charter for the protection and promotion of substantive equality. It is very important to mark here substantive equality of opportunity for all. Everyone has the opportunity, should be given equal opportunity at every stage, whether that is of profession or otherwise. So this was the case title, Andrews versus Law Society of British Columbia. This is the first case law, first decision on equality rights. So this was decided in 1989. Moving forward at the third case law, free speech and advertising to children under 13. Irvine Toy Limited aired television ads for toys aimed at children. Quebec's Consumer Protection Office charged Irvine Toy with offenses under the Provincial Consumer Protection Act. The act did not allow commercial advertising aimed at children under 13. Irvine Toy Limited challenged the act, saying it unjustifiably limited their freedom of expression. So Supreme Court decided that while the act limited the freedom of expression of the toy company, this limit was reasonably justifiable because the law pursued the important goal of protecting children under 13 who were particularly vulnerable to commercial advertising. This law did not go further than it needed to, since Irvine Toy Limited could still advertise children products to adults. So in this case, the decision by the Supreme Court was that the advertisement of children products can also be made by the adults. So the very purpose of the law was saved, that the children under 13 should not be particularly vulnerable to commercial advertising. So the judgment is Irvine Toy Limited versus Quebec Attorney General 1989, 1 SCR 927. Thanks for watching the video. Thank you very much.